This is the time and place for the March board hearing, Wednesday, March 23rd, 2022. We've got a full docket today, and to get us started, we'll go through our briefing session with Director John Baza. Welcome, everybody, and we see that we have all but one of our board members. One is excused for personal reasons. And having said all that, I'll turn the time over to you, Director Baza.
Thank you, Chairman Hanson and members of the board. Welcome to your meeting in Salt Lake City. I'm John Baza. I'm the Director of the Division of Oil, Gas, and Mining. And this morning, again, we've tried to keep our briefing session pretty minimal so that you can carry on with other business as needed. But to begin with, seated next to me is Natasha Balev. She's our legislative and policy coordinator for the division, and she's going to give you a legislative update and wrap up from the session that just recently adjourned.
Yeah. Good morning. Again, I'm Natasha Balev. I'm the legislative and policy coordinator. So a lot of this information you got a couple weeks ago in an email, but let's just go over it again. So for a legislative update, we had House Bill 22, the Open and Public Meetings Act. This may or may not need rulemaking based on what you as the board decide. So it requires that a quorum be calculated, and it prohibits voting by proxy unless it's stated in rule or a resolution. So if you guys would like to vote by proxy, that's something that we would need to do for rulemaking. It's not on the slide, but it also requires all non-unanimous votes be counted by roll call. I don't think that's really an issue. I think we do roll call votes a lot here. And then House Bill 244, geologic carbon sequestration. This bill established pore space, authorizes the division to apply for primacy for Class 6 injection wells, and then it also authorizes rulemaking in regards to carbon sequestration. This one had a fiscal note that John Baza will discuss in a moment. House Bill 378, mining operations. This one amended the definition of boulder and exempted it from mining activities. So the intention behind this was if a farmer on his land is trying to move rocks or anything like that, they would not fall under our regulatory authority. So we will need to do some rulemaking on that. And I'll also discuss that later in the briefing. Senate Bill 97, solid and hazardous waste. This removes the requirement from E&P waste facilities to acquire gubernatorial and legislative approval in the permitting process. In 2020, during the 2020 legislative session, that was added to the process, and so this is just making it a little bit easier, and this is something that I'll discuss later as well. Senate Bill 146, oil, gas, and mining amendments. This amended the definition of crude oil and oil to clarify regulatory authority for tar sands. So if tar sands come out as a liquid, it will be regulated by our oil and gas program. If it comes out as a solid, our minerals program will continue to regulate it. And then finally, Senate Bill 250, mineral exploration tax credit. This gives a tax credit to certain mineral exploration activities, and only if that company has paid a certain amount of severance tax already. So the division will need to create a whole new program so that we can fulfill this bill. So I'll turn the time over to John to discuss the fiscal side of the legislative session.
Thanks, Natasha, and she'll be speaking more in just a few minutes, but I did want to talk to you about the appropriation side, because that's somewhat separate from the things that we follow in terms of legislation. But the division asked for 3 building blocks this year, and 2 of them I think were supported through the governor's office. The third one was put on hold somewhat, but the building block that we got from the legislature, there was one for attorneys' costs. If you remember back a couple of years ago, we had the penalties rule and legislation, and it allowed for basically half of an FTE to be costed out for the purposes of administering that penalties rule. Um, we asked for the other half of FTE this year because we realized that uh, much of our work is become very legal in the past few years. It's created bottlenecks in terms of rulemaking, in terms of enforcement actions. So we did feel like we wanted to ramp up and get that full attorney, which would now allow the AG's office to hire somebody into that job. So we did get that. That was approved by the legislature. We also got a building block, which was kind of split into two pieces. One was for staffing increases, and one was for data enhancements, specifically to um, improve efficiencies within the division. Those were other bottlenecks that we saw. That one was, we can see our staff is accomplishing quite a bit and is doing quite well to meet service the extractive industry's demands. But we also feel like that is a serious bottleneck to how we can expand in the future. I mean, take, for example, if a railway was built out in the Uinta Basin and there's additional drilling and whatnot, we certainly would not want the activities of our program to be limiting at that point. So we did get some dollars for additional staffing as well as for data enhancements, which was something that um, we've kind of done periodically over the years because we've recognized that data is our salvation in terms of getting good work done in the division. And with the work that we're seeing both on the inspection side, the permitting side, in mining, and in oil and gas, we feel that it's appropriate to keep investing in those tools that allow our staff to extend their reach. And that was approved by the legislature as well. And then Natasha mentioned the fiscal note for carbon sequestration. Um, we actually asked for more than what we got. We had asked for some attorney's costs in that one as well, because standing up a program is not as easy as saying, oh, we're going to hire a few people and create some rules on this. In this case, we have to apply for primacy delegation from the US EPA to manage a Class 6 program. When we've talked to other states, this is a tremendous amount of effort, multi-years. In the case of Wyoming, I think they've done it most recently, and it took them a little over 2 years. It requires a lot of rulemaking. But rather than give us the attorney's costs, I think the legislature felt like they wanted us to start the costing of the program, stand something up, and then come back to them through the normal appropriations process and ask for more money as needed, which we're committed to do. But the dollars that we got for carbon sequestration is one-time funding in the amount of $320,000. That allows us to hire 2 or 3 people to get the program started, get the application process started, but we'll definitely need more as time goes by. So I think either one of us are happy to answer questions on any of that. Oh, by the way, on the minerals extraction tax credit, that will be a new program as well. So there is a fiscal impact on that, but we've already got dollars coming from the severance tax, and we think that we'll be able to manage within that budget that we have. Any questions?
Board members, do you have questions of Director Baza or Natasha? I guess I'll wait till you go further into your presentation. I know you're excited about having more rulemaking.
Yes, that is what I live for, is rulemaking. So continuing into rulemaking, bringing up the same bills again, except for the Open and Public Meeting Act. Unless you guys decide on that, please let me know and I'll add it to my list. So the geologic carbon sequestration, we're expecting that this is going to be a long process. This is something that, as we're applying for primacy, we'll find out more information about what we'll need to put into the rules. So that's going to be on our list for a while. The mining operations bill, this one we think will be a fairly simple process. We should only be changing the definition of boulder and mining activities. Solid and hazardous waste. This is something that rulemaking isn't necessarily required, but we will be working with waste management as they start to pick up their program. So there may be rulemaking in the future on this. If you have more questions about it, I would defer to Bart Kettle. He can talk all day about it. And then oil, gas, and mining amendments, the tar sands bill. This one should be a fairly simple process as well, just changing the definitions of crude oil and oil. And then the mineral exploration tax credit. This one will be a little bit more involved just because we are starting a new program, but we do have a well workover tax credit process within the oil and gas program. So it should be fairly similar to that. And then moving on to our other rulemakings, we do have board ordered rulemakings. That is the horizontal wells and the mineral suspension. The division high priority rulemakings include bonding and facilities, so that will also deal with the waste management. And then division recommended rulemaking is seismic exploration. I don't have it in the slide, but I did file a memo with the board on 5-year renews. So this one actually deals with all of the board rules. There's 19 of them. I'm not sure how many of you looked at the memo. But right now I am asking for approval from the board to renew the board rules. These come up every 5 years. I know that we've had a couple come up in the last year or two. So just to ensure that everything runs smoothly, just asking for approval. And then if I know that there's a lot of stuff that needs to be updated within these rules. I'll start making a list and then we can start going through and updating all of the rules. But just to make sure we're keeping with the status quo, we will need to renew them. And it comes up on January 7th. So, or not January, sorry, June. I know how to read. But yeah. Is there anything you wanted to add? Just wait for them.
Now the appropriate time to ask a few questions.
Yes.
All right, thank you. On the if you could go back a slide or two. Okay, the mining operations bill. Just curious about how you define. I know how you define a boulder. How do you define the impact of mining that boulder? I mean, how do you draw the boundaries around that before it becomes a mining operation?
This was actually a more complicated bill than it appeared on its face. It was our understanding that there were quite a few landowners in central Utah who had concerns about when they were trying to remove rocks from their properties so they could, cultivate or do other activities on their property. They didn't realize that they were actually under the regulation of our minerals program. So it created some tension involving bonding requirements, what was anticipated in terms of reclaiming their activities. And honestly, the biggest problem occurred when a landowner was contracting with another third party to remove those boulders and to sell them, that the landowner wasn't always getting what was promised. And so this was an effort by the legislator who sponsored it to say, let's give landowners the ability to remove these boulders without being subject to Division of Oil, Gas, and Mining regulations. So there is a definition in the bill for boulder. It's rather broad, but it talks about a boulder is anything more than 75 millimeters in size. It has to be a consolidated material within an unconsolidated matrix. And so there's a few issues on that. And I think the sponsor was really adamant of getting this bill passed in this session, but committed to the fact that if changes need to be made because of difficulties with how we would regulate this, that he would be willing to bring it back in a future session and make corrections to the statute.
Thank you. I was just trying to figure out how do you, as I recall, the bill allows him to sell those boulders, but not be considered a mining operation.
Correct.
I can see some areas where there might be a little bit of gravel operation that's not a gravel operation or rock operation. Mr. Board?
Yes, could I follow up with a question on that as well? Is there any limitation as written as far as the tonnage that could be removed per acre, or the depth that could be excavated before it? So if you're on an alluvial fan that's got a coarse open stockwork, a pile of boulders on it, you could go down as far as you want and sell those. So.
Yeah. So Dana Dean, our deputy director, she's online and she's also raising her hand, so she can speak a lot more to it if we would like her to. So I guess we'll see if she can.
Do you want me to? Board?
Dana has raised her hand and is ready to comment.
Go ahead, Dana.
Okay. Yeah. So as John said, the representative wanted to pass this bill. There was a lot of pushback on putting any sideboards on it. So you're correct. There are no tonnage limits or depth limits in the bill. If they are removing any material that's consolidated, then it becomes mining. So this is really meant to capture what happens in San Pete County, where there's a lot of boulders there that are in farmland. And if they're just removing those boulders, then they should be exempt under this new law. If they hit consolidated material, then it becomes mining. It's not ideal the way it's written right now, but we did get a promise from Representative Lund that if we see problems with this and it makes our job harder, and there are issues where we can't differentiate between what he was trying to exempt and something that should not be exempt, then he'll work with us to fix that in the next session. So we're going to be documenting over the next year what has been exempted under this bill and what problems we might face as we're trying to implement the new law.
Thank you. Any other comments or questions on any of the bills? Just a question, Natasha, on the renewal of the regulations that you're asking for. Are you asking for the board at this time to instruct the division to move forward with renewal?
Yes, please.
Does that require a vote, a motion and a vote? Well, I guess are you ready for us to proceed?
Yeah.
So board members, the need is for a motion to renew. Maybe I better get a good list here.
Yeah, there's 19 of them. I can pull it up. It spills over onto 2 pages, by the way.
Wait a minute. Need to get on my. glasses here. My goodness.
Sorry, that doesn't even show all of them.
I think Mr. Begley brings up a good point that a motion can reference the division's request so that we don't have to read each one of these R641 rules that are up for renewal. So is there a motion to renew these regulations?
I'll move to renew the regulations set out in Natasha's letter.
Is there a second?
Second.
Discussion on the motion? Hearing none, we'll take a vote. All those in favor say aye.
Aye.
Any opposed? The motion passes unanimously.
Awesome. Thank you.
Thank you, Natasha.
Thank you, members of the board. We'll move on in the agenda. There are some other items I need to bring to your attention. One is that you may have heard or seen newspaper reports or whatnot that last month the division had issued a cessation order for a period of time to Alton Coal for their operation down in Kane County. That was to address some bonding issues and some concerns that we had over the bonding that Alton had in place. I believe the cessation order lasted for about 10 days until Alton did provide that bonding, and we lifted that cessation order as quick as we could, and they're back to full mining at this point. So I'm happy to answer questions, or if Dana needs to answer questions, I'm sure she can weigh in. But at this point, they're back to full operation at that facility. The second thing I'll bring up under other items is we've had some issues arise that will necessitate that we have a board hearing in May here in the Salt Lake office because of some complicated issues that are coming up. I've talked to the Utah Petroleum Association, and they are willing to postpone their hosting of a board field trip out to the Uinta Basin that month. We haven't yet decided when is a more appropriate time, and perhaps we can have a conversation later on with board members and see what would be fit into their schedules in terms of scheduling a field trip out to the Uinta Basin. But for the time being, we're going to have to put off traveling out there in May and do our hearing here in Salt Lake City in May. So I just wanted to inform you of that.
Director Buzzard, are these field trips typically open for the public to participate in?
They fall under the Open and Public Meetings Act, so we do have to post an agenda and allow public participation. But it's pretty limited. They have to provide their own transportation on the field trip. We don't provide meals for the public or anything like that.
Okay. Just thinking that maybe a discussion as to the board members' feelings on when a field trip might take place. Now might be a good time to have that conversation. Is that, do we want to have a field trip that would be in addition to a hearing or coincide with the hearing? In other words, the day before the hearing or the day after the hearing, or do we have one a week or two before the hearing? Do the board members have any thoughts on that? Preferences?
Yeah, with my prior employer, we did field tours and things periodically. We did a tour and then followed up the next day with a board meeting. So it was an overnighter for the and staff. I'm sorry. Speaking to tonight. Do you need me to repeat that? When I was with my former employer, we would hold out of town meetings, and we organized it to do a tour one day followed by a board meeting the next day. So it meant an overnight for staff and board members.
If I could comment, Mr. Chairman,
Absolutely.
that's actually what creates the complication in May, is that we were trying to do a field trip and a field hearing, and it's really a difficult thing to organize and try to orchestrate when we have a complicated hearing matter that comes up like it is in May.
I was just going to add my 2 cents. For me, it's easier if they're scheduled side by side, but I understand there's also other constraints.
Any comments from any other board members? I understand the issue, and I know that you're concerned about how we organize this so that we're not taking up too much of people's time and at the same time be efficient. But we can't really always anticipate what matters are coming before the board at that time. We'll have to give it some thought, Director Boz, and I appreciate the fact that you're telling us this now in March before our previously scheduled field trip in May. We'll have to figure this out because I think everybody does on the board want to conduct or go on this field trip.
Right.
We'll just have to figure out how best to arrange that.
Well,
schedule.
and I'd let you know, as complicated as it may be, we will find a way to do whatever the board would like done. And if it's to coincide with a board hearing date, we'll make it happen somehow. But just know that, as you said, we can't always anticipate the complexity of our hearings.
Yes. Back to the previous matter you discussed about the Alton issue. The division's confident that the bond meets the requirements set forth in the regulations for bonding.
You know, I probably can't go into it at this time because it may be a matter that comes before the board again, but there are some complexities to that we're going to have to sort out right now.
Okay, I appreciate that. Thank you. Anything else for the briefing session?
No, I'm sorry. Thank you. We'll conclude our briefing part of this and we'll turn it back to you, Mr. Chairman, and the board for the remainder of the hour.
Thank you. At this time, well, there's a little bit of housekeeping I need to take care of. Today, during our lunch period, we had anticipated having some training for the board, but that's going to be continued to a later date. We also will take care of it during the lunch period, an evaluation or review of the single nomination we received for the Environmental Excellence Award. And as listed in the hearing documents, the briefing documents, it will be televised. We'll figure out how to make sure that happens. I think that we've got it arranged so that those who need to participate in the discussion, we can do this in the board conference room. Not sure what you call that room other than our lunchroom. But that's where we'll have that evaluation take place. Now, typically at this point, we ask if there are any public comments that need to be heard at this time. I want to make sure that those who want to comment understand that we do not wish to hear comments about those matters that we will be hearing in the next portion of our hearing, that is the scheduled agenda items. So if there are comments that the public would like to make that are not related to our scheduled agenda items, I think we can go forward. Julianne, did you receive any requests for comments that would be not related to these future matters?
You can hear me. I did not, there was one that could be classified for one of the matters, but it could also be modified to qualify for public speaking during this period. And I'm not sure how that is going to play out.
Do you, who and what is the matter? Do you recall?
Yes, I'm looking that up right now. Yes, it was Mr. Scott Williams.
I'm sorry, it was Mr. Scott Williams.
It was Mr. Scott Williams. Is he participating virtually, and does he want to speak up?
Yes, I'm here. Yeah, can you hear me?
Yes. And is this a comment related to, say, the tree farm matter?
Well, it's related to the division's motion for policy clarification, which has the tree farm docket number attached to it. I'm happy to either comment now or wait until the tree farm agenda item.
I think it's appropriate to wait in that,
Okay.
for that comment. So thank you.
Yep.
So in that case, I'm sorry, go ahead, Julianne.
I was going to say with that, Mr. Chairman, I have no knowledge of any other requests to speak
Okay.
during the briefing session.
Thank you. In that case, hearing no further requests for public expression of opinions, I will we'll go ahead and break before we embark on our hearing our agenda items. We will return at 10 o'clock to start the formal portion of the hearing today. So we'll go off the record and resume at 10 o'clock. Thank you.